Hello and welcome to Courts This Week by LiveLaw. I'm Debojeet Das. This week, India's courtrooms dealt with questions that cut right to the core of constitutional governance: bodily autonomy, electoral integrity, digital privacy, preventive detention, religious freedom, executive power, and the everyday consequences of center-state disputes. From the Supreme Court reaffirming that no woman, not even a minor, can be compelled to continue a pregnancy, to sharp judicial scrutiny of voter roll revisions, data practices of big tech, anti-conversion laws, and the continuing use of demolitions as a punitive tool, the courts were anything but quiet. Here's a detailed look at the most important legal developments from across the country this week. Our first story this week comes from the Supreme Court, and it's the language used by the judges that makes this ruling particularly significant. While allowing the termination of a 30-week pregnancy of a minor, the court squarely focused on the minor's autonomy and lived reality, not on abstract moral or legal classifications. The bench observed that what truly mattered in this case was the right of a minor girl to decide whether she wants to continue a pregnancy. That is, in the court's words, ex facie illegitimate, simply because she herself is a minor and finds herself in the situation due to a relationship she had. The judges made an important clarification here. They said the issue was not whether the relationship that led to the pregnancy was consensual or whether it amounted to sexual assault. That distinction, the court noted, did not change the core facts before it. What mattered was this: the child to be born would be illegitimate in law, and the minor mother clearly did not want to carry the pregnancy forward. The bench was categorical that no court can compel a woman, especially a minor, to bear a child against her will, and that statutory timelines under the Medical Termination of Pregnancy Act cannot override the constitutional guarantees under Article 21. Forcing continuation of the pregnancy, the court effectively said, would amount to imposing further trauma on the child who is already in a vulnerable position. By framing this issue this way, the Supreme Court made it clear that reproductive rights are about choice, dignity, and autonomy, not about policing relationships or fitting facts into rigid categories. When a minor's bodily integrity and future are at stake, humaneness must guide the law, not technicalities. And for our second story and how it unfolded at the Supreme Court and why it escalated beyond a routine election dispute. For the first time ever, a sitting chief minister personally addressed the Supreme Court. Mamata Banerjee appeared in court to challenge the special intensive revision of voter rolls in West Bengal, alleging that the process was being weaponized against the state. Her submission was strikingly direct. Banerjee told the court that SIR was no longer about inclusion, but deletion. She argued that the exercise was rushed, opaque, and causing serious unaddressed hardships on the ground. According to her, voters, particularly women who changed surnames after marriage, were being flagged and robbed over spelling mismatches and vague logical discrepancies. That phrase, logical discrepancies, dominated the hearing. Banerjee claimed that 1.36 crore voters are currently stuck on this discrepancy list, many without resolution notices, while only 11 days remain before the final electoral rolls are published, making meaningful hearings practically impossible. Another flashpoint was the appointment of micro-observers. Banerjee alleged that around 8,000 micro-observers allegedly affiliated with the BJP were appointed to override booth-level officials traditionally responsible for maintaining voter rolls at the grassroots. In her telling, this amounted to sidelining local election machinery in favor of centralized control. The Election Commission of India, however, pushed back strongly. Senior advocate Rakesh Dwivedi, appearing for the ECI, told the court that the state had failed to provide enough Group B officers for the SIR. Because of that non-cooperation, he argued the commission was well within its powers under the Representation of People's Act to deploy micro-observers. Matters intensified further when ECI filed an affidavit accusing the West Bengal government of obstructing this SIR process, alleging threats to election officials and provocative public statements by the Chief Minister herself. Among the 14 reliefs sought by Banerjee were setting aside the SIR notification altogether and directing that the 2026 West Bengal elections be conducted using the last year's electoral rolls. A detailed coverage of the 14 reliefs is accessible on our website. And for our third story, where the Supreme Court has drawn a hard line on the controversy over steep nomination fees in state bar council elections, and this time it has effectively ended that discussion. A bench led by Chief Justice of India Suryakant along with Justice Joy Mallya Bagchi upheld the Bar Council of India decision, fixing the nomination fee at 1.25 lakh rupees. More significantly, the court directed all high courts not to interfere in Bar Council election processes on this issue and declared that every pending writ petition before high courts challenging the fee would stand dismissed. This wasn't unfamiliar ground for the bench. Just last year, when the BCI raised the fee from 9,000 rupees to 1.25 lakh rupees, the very same judges had refused to intervene, even after petitioners highlighted that the Delhi Bar Council alone allegedly has reserves running close to 100 crore rupees. Even then, the court declined to step in. The court's mood this time was unmistakable. Justice Kant questioned the urgency behind contesting elections, remarking, half in jest, "What is the tearing hurry to contest? Let them contest later. Their supporters will take care of the amount." The present order arose from a petition filed by the BCI seeking transfer of a challenge pending before the Delhi High Court, where lawyers argued that under the Delhi Bar Council rules, the nomination fee is only 500 rupees and that the BCI lacked authority to impose a higher amount. It was even suggested that if funds were needed, the BCI should approach the government instead. The bench was not persuaded, however. Justice Kant cut to the point. "Why contest elections at all if you cannot pay the amount?" he remarked. He added that state bar councils are not commercial bodies and survive on membership fees, so there was no reason why those funds should be spent underwriting individual election campaigns. Moving on to our fourth story this week, where the Supreme Court laid bare a sharp center-state standoff with teachers caught squarely in the middle. The case came from Uttar Pradesh and traced back to a 2013 government order under the Sarva Shiksha Abhiyan, through which the state appointed nearly 10,000 instructors for physical education, art and work education. They were first paid 7,000 rupees a month, later revised to 17,000 rupees, and on paper the hike happened, but in reality the payments did not follow through. Before the Supreme Court of India, the Uttar Pradesh government pointed to the funding formula under the Right to Education Act of 2009, arguing that the education expenses are shared 60:40 between the center and the state. Since the union allegedly failed to release its 60% share, the state said it could not be forced to shoulder the full burden. The court rejected that logic outright. Relying on Section 7, subsection 5 of the RTE Act, the bench held that the primary and overriding duty to implement the law rests with the state. A funding dispute with the center, the court made clear, cannot be used as a reason to underpay teachers or compromise educational standards. The direction was unequivocal. Pay the instructors 17,000 rupees per month. At the same time, the court clarified that the state is free to later recover the center's contribution, applying the principle of pay and recover. Put simply, pay the teachers first, fight the financial battle later. The Supreme Court sent a strong message that center-state disagreements cannot be allowed to spill into the classrooms. Because when governments pass the buck on something as basic as educators' wages, the real cost is paid by the future of education itself. And moving on to our fifth story this week, the Supreme Court took on one of the most powerful tech combinations in the world, that is Meta and WhatsApp, and the hearing turned into a sharp interrogation on privacy, choice, and digital power. A bench comprising Chief Justice of India Suryakant, Justice Joymalia Bagchi, and Justice Vipul Pancholi was hearing appeals linked to WhatsApp's controversial privacy policy. Senior advocates Mukul Rohatgi, appearing for Meta, and Akhil Sibal for WhatsApp, told the court that the penalty imposed earlier had already been deposited, but that did not soften the bench. Chief Justice Kant directly questioned WhatsApp's claim that users are given a choice under the policy. In blunt terms, he pointed out that WhatsApp operates as a market monopoly. What is the choice, he asked. Either you accept the policy or walk out of WhatsApp, and then your data gets shared. The CJI went further, issuing a stern warning. The court said it may hear the appeal on merits, but until then, not a single piece of user data can be shared. He told Meta and WhatsApp to file a management-level affidavit with a binding undertaking or face dismissal. In striking language, the Chief Justice of India remarked that companies change hands. Facebook bought WhatsApp. Tomorrow someone else may buy Facebook, but users' privacy cannot be treated as transferable property. You cannot play with the right to privacy of this country, he said, adding that a clear message must go out. The concerns were not abstract. Justice Bagchi said the court wants to closely examine how user data is effectively rented out and how behavioral patterns are analyzed to push targeted advertisements. Chief Justice Kant even shared a personal example, saying that after WhatsApp conversations involving medical advice, he noted targeted ads for medicines appearing on email and YouTube within minutes. That, the bench suggested, raises serious questions about data exploitation. The Solicitor General of India, Tushar Mehta, reinforced this concern, telling the court that personal data today is not just sold, but commercially exploited. In response, Rohatgi and Sibal strongly maintained that WhatsApp messages are end-to-end encrypted and that even WhatsApp itself cannot read user chats. This case could well shape how digital consent and data rights are understood in India going forward. Moving on to our next story, and here's what unfolded at the Supreme Court of India when Jan Suraj Party, founded by Prashant Kishore, challenged the Bihar Assembly elections and why the court was clearly unconvinced. The Jan Suraj Party moved the Supreme Court under Article 32, attacking the direct transfer of 10,000 rupees to women voters in Bihar at a time when the model code of conduct was in force. The allegation was that this amounted to an election freebie that distorted the level playing field. Right at the outset, Justice Joy Malia Bagchi posed a fundamental question. Under which clause of Section 100 of the Representation of People's Act can an entire election be set aside? That question set the tone for what followed. The petitioners argued that the Supreme Court is already examining the broader issue of freebies and said this case raised a serious concern. He pointed out that Bihar is a fiscally stressed and highly indebted state, and offering cash transfers worth thousands of crores during elections without clear budgetary backing would seriously skew electoral fairness. Singh added that the scheme allegedly covered over 1.56 crore women without prior scrutiny while the model code was operative. But the bench was not persuaded by the form of the challenge. Chief Justice Suryakant described the petition as a composite election petition seeking an omnibus order to nullify the entire election. He stressed that elections cannot be set aside in bulk. There must be specific allegations of corrupt practices against individual candidates. When the petitioners insisted that they were raising a larger constitutional issue about violation of the model code, the Chief Justice of India pushed back sharply. How many votes did your party get? He asked, adding that if people reject a party at the ballot box, the code cannot be used as a route to political relevance. The Chief Justice of India also pointed out a glaring flaw. If the problem was the cash transfer scheme, that scheme itself should have been challenged. The petition, however, did not even seek to quash the scheme. It only asked for the entire election to be set aside. Moving on to our next story this week, where the Supreme Court continued hearing a habeas corpus petition filed by Dr. Gitanjali Angmo, challenging the preventive detention of climate activist Sonam Wangchuk under the National Security Act of 1980. The matter is before the bench of Justices Arvind Kumar and P.V. Varale. Defending the detention, Solicitor General Tushar Mehta mounted a strong case for the union. He told the court that Wangchuk's repeated references to Gandhian values were a deliberate facade masking inflammatory intent. Reading from Wangchuk's speeches, Mehta argued that the activist was attempting to provoke a Nepal-like Gen Z protest in a sensitive border region, even urging the youth to draw inspiration from the Arab Spring, which saw governments fall amid violent unrest. According to the centre, this went beyond peaceful dissent and amounted to calculated provocation. This position was reinforced by Additional Solicitor General K.M. Nataraj, who claimed that Wangchuk's September 24th speech directly preceded violent protests in which 4 people were killed and 161 injured. He stressed that detention passed through multiple safeguards: state approval, review by an advisory board headed by a former High Court judge, and an independent power with the state to revoke or continue detention, and argued that none of these subsequent orders had been separately challenged. The bench, however, was skeptical of limiting scrutiny. Justice Arvind Kumar noted that such arguments may not hold when the detention order itself is under challenge, a view Justice Varale agreed with. On the petitioner's side, senior advocate Kapil Sibal had earlier raised core due process concerns. The detention order was served after 28 days, but the materials relied upon, including 4 videos, were never supplied, making an effective representation impossible. He also pointed out that Wangchuk's peace appeal speech was never placed before the detaining authority. Significantly, the hearing ended with the bench noting that Wangchuk's health is not good, and Justice Varale asking the union to reconsider whether continued preventive detention is necessary, at least on medical grounds. Moving on to our next story this week, where the Supreme Court of India began examining a wide-ranging constitutional challenge brought by the National Council of Churches in India against anti-conversion laws enforced across 12 states. This National Council told the court that it represents 32 member churches, 17 regional Christian councils, 18 all India organizations, and 7 related agencies, together speaking for nearly 1.4 crore people. While this particular petition directly challenges the laws in Odisha and Arunachal Pradesh, it is part of a larger legal movement, with the court already having issued notice in December 2025 on a challenge to the Rajasthan's 2025 anti-conversion law. At the heart of the case are serious constitutional objections. Appearing for the National Council, senior advocate Meenakshi Arora argued that these laws are structurally designed to presume wrongdoing. Many of them require individuals to prove that a religious conversion was voluntary, effectively reversing the burden of proof, which she said strikes at the core of criminal jurisprudence and personal liberty. The petition also attacks the vague and overbroad wording of key provisions. Terms like allurement, inducement, or undue influence are left undefined, allowing ordinary acts like charity, prayer, or even personal conversations to be criminalized. This vagueness, the National Council argues, gives unchecked discretion to police and local officials, making lawful religious practice legally risky. Another major concern flagged was discrimination. The laws, according to the petition, disproportionately target minorities by placing prior permission requirements and post-conversion scrutiny almost exclusively on religious conversions away from Hinduism. This, the National Council says, violates Articles 14, 21, and 25 by singling out certain faiths and burdening individual conscience. Perhaps most troublingly, Arora warned the court about the rise of vigilante enforcement. Several of these laws contain reward or incentive mechanisms, which the petitioner says encourage private individuals and groups to file complaints. Even baseless accusations can lead to arrests because the system rewards those who report alleged conversions, creating a climate of fear and harassment. Taken together, this challenge argues that these laws don't merely regulate conversion, they chill religious choice itself. As the Supreme Court takes this up, the case squarely asks whether the state can police belief without eroding the Constitution's promise of liberty, equality, and freedom of conscience. And our next story this week brings us to the Bombay High Court, where comedian Kunal Kamra has mounted a significant challenge to how online content is being regulated by the government. At the center of Kamra's petition is the Sahyog portal and a 2025 amendment to Rule 3, Clause 1D of the Information Technology Rules. Put simply, the argument is that this framework allows government authorities to flag and seek the blocking of social media content through a centralized portal without going through the established legal process of blocking online speech. That established process is key to understanding this dispute. Under Section 69A of the Information Technology Act, the power to block content is tightly regulated by the 2009 blocking rules. These rules require the government to identify the content host or originator, issue a formal notice, and give them 48 hours to respond before any blocking decision is taken. Even critics of Section 69A argue that these procedural safeguards, limited as they may be, exist to ensure at least a minimum level of due process. Kamra's petition argues that the Sahyog portal effectively sidesteps this structure altogether. According to him, content can now be taken down through executive coordination without prior notice to users, without a hearing, and without accountability, creating what he calls a parallel content blocking regime. The challenge raises deeper constitutional concerns as well, whether such a mechanism violates principles of natural justice and undermines free speech protections, especially when users may not even know why their content disappeared. And we end this week at the Allahabad High Court, where a bench has raised some of the most direct judicial questions yet about what is described as bulldozer justice in Uttar Pradesh. A division bench of Justice Atul Sridharan and Justice Siddharth Nandan noted that it has repeatedly come across cases where demolition notices are issued almost immediately after an alleged offense is registered, a pattern the court said cannot be ignored. The bench framed a set of pointed constitutional questions. First, whether authorities are violating the Supreme Court's November 2024 judgment, particularly paragraphs 85 and 86, which strictly curtailed punitive demolitions. And second, whether merely having a statutory power to demolish is enough, or does the state have a duty not to destroy homes unless there is a genuine public purpose. The court also asked whether demolitions carried out right after an offense amount to colorable exercise of executive power, and how high courts are expected to balance demolition powers with Articles 14 and 21, which protect equality and right to life and dignity. Perhaps most strikingly, the bench asked whether a reasonable apprehension of demolition itself can be grounds to approach the court, and if so, what minimum threshold must be met. These questions arose in a writ petition filed by Faimuddin and others, who said that although their relative, Afan Khan, was named in an FIR under various provisions, including BNS and the IT Act, they themselves were not accused. Yet, they alleged being targeted by a mob acting in collusion with the police and feared that their residential house, lodge, and sawmill in Hamirpur were marked for demolition. That's all for this edition of Courts This Week. We'll continue tracking these cases as they unfold. But for an in-depth, accurate, and timely legal reporting, visit livelaw.in. Thank you for watching, and we'll see you next week.